In this presentation, we are discussing water rights versus water shares. This is an area with some confusion, so we'll be addressing several common questions. First, what are water rights and what are water shares? Is there a difference? Let's start by defining what a water right is. Water rights in the state of Utah are considered real property created within Title 73 of the Utah Code. They entitle the owner to divert and beneficially use water within the limits of the water right. They are pertinent to the land, meaning they are generally attached to the land and the ownership transfers with the land unless they have been severed. As a result, the County Recorder's Office is the office of record of ownership for perfected water rights. Again, as its name would suggest, a water right gives the owner the right to divert and beneficially use water within the limits of the water right. Now let's define a water share. A water company or other entity that owns a water right will divide it into equal interests and sell the shares of stock in the company. You own a share in that company's base water right or water rights, and you usually pay an annual assessment to that company. Shareholders are entitled to use a proportionate share of water within the limits of the company's water right. Water shares are generally not appurtenant to the land. If you own a share in a company and you sell your property, that water share doesn't usually transfer automatically. However, they can be sold, so someone selling their land could also sell their share in that company. In that case, the company would reissue the stock in the new owner's name. The company keeps records of the numbers of shares it has and who owns them. A common area where people encounter confusion between water shares and water rights is the process of filing a change application. The process is slightly more involved for those who own water shares, as there are a couple extra steps. Let's say you own a share in a company and you want to use that water somewhere outside the limits of the company's water right. For a water share, it is a three-part process that includes preparing a change application, submitting the change application to the company for approval, and coordinating with the company to make any corrections to the proposed change application before filing it with the Division of Water Rights. Before preparing a change application, the applicant first needs to prove they own a share in the company. To do so, they must provide a copy of their stock certificate issued by the company to the Division of Water Rights. The division will then issue what's called a share statement, which defines the limits of that water share based on the underlying company water rights, including its approved beneficial uses and the place of use. The division will also create a water right number for that share. Keep in mind, that doesn't mean it becomes a water right. It is still a water share. The division is creating a water right number for bookkeeping purposes. It is still a share of stock based on the company-owned water rights. So you may ask, what needs to be on the proposed change application? Well, it needs to include the certificate number of the stock affected by the change, a description of the land proposed to be retired from irrigation if the share is based on irrigation, an agreement by the shareholder to continue to pay all applicable corporate assessments, and any other information that the water company may need to review the change application. I'll add a side note here. A common point of concern is the belief that completing a change application on a water share will reduce the company's water right. That is not correct. Some of the company's use is taken out of production in order for the shareholder to use the water in a new location, but the company's base water right is not reduced. If that change application lapses or is withdrawn, it reverts to the characteristics of the company's base water right. The next step is for the company to review the proposed change application. The company, by statute, has 120 days to respond in writing to the proposed change application. The company then has three different options. First, they can consent to the change application, in which case they'll sign it and send it back to the shareholder. Second, they can consent subject to conditions. Or third, they can decline consent, but they need to describe their reasons. Per Utah Code, they cannot withhold consent if the issue can be reasonably mitigated without cost to the company. In some cases, they can require the shareholder to pay additional fees within reason to mitigate cost to the company. It's important to note if the two parties cannot come to an agreement, sometimes it can move to litigation and be settled in a court. If the company does not respond within 120 days, it is deemed as consent. In that case, the shareholder can provide an affidavit stating the company was given the proposed change application, what date it was provided to the company, that 120 days have passed, and the shareholder wants to proceed with filing the change application. Because of this, we recommend the shareholder acquire documentation, such as a dated receipt, proving the application was delivered to the company. The company may consider whether the proposed change will increase their costs, whether it will interfere with their ability to manage and distribute water, whether the quantities of water fit within the share that the shareholder owns, and whether it will impair quantity or quality of water, including carrier water. They may also check to make sure that the proposed change application doesn't violate statute if they retire the current uses. Finally, the applicant, once they get consent or once 120 days have passed, can file the change application. Once that change application is approved, they can use that water as approved in the change application. The company does not need to be involved for the applicant to submit requests for extension of time to submit proof of beneficial use. Here are some questions to consider while I summarize the differences between water rights and water shares. To review, water rights are owned by the water user. They don't pay any assessments, and they can use that water in accordance with its approval. They generally transfer by appurtenance when the land is sold. With water shares, a company owns the water rights and it sells stock in the company. Shareholders pay an assessment to keep their shares in good standing. Water shares generally do not transfer by appurtenance. Shareholders can file a change application if they desire to use the water in a manner outside of the approved uses and places of use of the company's base water rights with the company's consent.